Good afternoon, everyone present here. The Faculty of Law Integral University Lucknow, with Association of Indian University under the aegis of the Human Resource Development Center, is going to conduct 1 month faculty development program on the theme Integration of Intellectual Property Rights Principles into Teaching Research and Professional Activities. As we gather here today, we are reminded of the importance of intellectual property rights in our daily lives, from the latest technological innovations to the creative works that shape our culture. IPRs play a crucial role in the protecting and promoting innovations, creativity, and entrepreneurship. As educators, researchers, and professionals, it is essential that we stay informed about the latest developments and the best practices in IPRs to ensure that our work is not only effective but also compliant with the laws and regulations that govern our activities. Today, we have first session of the faculty development program, and the theme of this session is importance of IPR protection, academia, and research. And to deal with this topic, we have our today's resource person, advocate on record in Supreme Court, Advocate Nidhi Sharma. Nidhi Sharma is a partner at Paralegal providing legal solution, and her specializations are in intellectual property laws, journal corporate and commercial advisory, employment and labor laws, and family laws. Nidhi Sharma, a law graduate from GGSIPU, enrolled with the Bar Council of Delhi, has over 10 years of experience in the legal field and has worked with various renowned names in the legal sector. Her broad spectrum of experience includes practice in various courts, tribunals, commissions, judicial and quasi judicial authorities across the country. She is also a panel counsel for the Municipal Corporation of Delhi. Nidhi Sharma has an academic bench of mind and is currently pursuing her PhD in the field of intellectual property laws. She also impaneled advocate for Bureau of Indian Standards, and she has also served as hearing office in Trademark Office Delhi. Without wasting such much time, I welcome Advocate Nidhi Sharma for his insightful thoughts. Over to you, ma'am. Welcome.
Thank you, ma'am, so much for giving me an opportunity and this platform to share my knowledge with other people as well from the faculty. And I will not take too much time in introduction of this topic. I will directly move on to the slides and will discuss the types of IPR, because we need to understand what are the categories of IPR we have in all over the world. So I'll be dealing with trademark, patents, copyright, and then I will be specifically discussing about what exactly is the importance of IPR protection for with respect to academics and research. So, what exactly is IPR? IPR is, these are the ideas and inventions, creative expressions, which are based on which there is a public willingness to bestow the status of property. That is a property, just like a tangible property or an intangible property. This is also a category of property. So IPR, it provides certain exclusive rights to the inventors and creators of that property, who have used their intelligence and developed their invented something, or some kind of creative idea is there which has been taken a tangible form. We protect that in IPR. So in other words, it means the legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. Now, what different types of IPR are there? First is patent, second trademark, third copyright. Another category of IPR rights is plant breeder rights. Now, this is a new category of rights. This comes under IPR and it has a specific act also, but people do not know much about it. So, since they do not know much about this particular category of IPR, so they do not know the what kind of rights or what kind of remedy which are available under this particular category. This is plant breeder rights. Another is utility model design. Next, geographical indications and trade secrets. Now, there are various categories of IPR. First, I will discuss about copyright. Now, as we all know, that what first the basic question which is to be understood here is that what what is the category of IPR which is protected under copyright? What all is protected under copyright? Now, any kind of idea which has taken a form, a tangible form, like if I have an idea about making a movie and I am writing the story of that, that particular thing is copyrightable under law. Similarly, when there is already a story and I make a play on that story, that particular play is to be copyrighted. All these categories like literature and art and ideas which has taken a form, a tangible form, all those things are protected under copyright. Now, it is not that easy when we talk about the protection of our rights under the IP, this category, what we call as intellectual property rights. And specifically, when we are talking about copyright, now there is a separate process for registration of your, to get your work copyrighted. Now, what is that process? I will discuss that process in brief. First, there has to be an application containing all the necessary particulars, and a statement of particular must be prepared in prescribed format. Now, there are various forms under various categories of IPR. You need to fill those forms along with an application. Now, what this application means? This is an application which contains the overall description of your work, the copyrighted work for which you are claiming the protection. Now, second step is after, this is, basically for people who do not belong to, either belong to law, and even if they belong to legal departments or they are lawyers or they are teaching law in universities, this is the process I have simplified and just jot down in a slide to make people understand that how you actually move on, how you go step by step to protect your work. Now, first there has to be an application, but that application needs not to be physically filed directly into the registry. Now, with the help of government initiatives and various other peoples, even for that matter, lawyers have taken that much initiatives. They have an online portal for that. Now, on that online portal, you have to get yourself registered through a link, and then you have to upload that application along with that form which you have filled to protect your work under Copyright Act. Now, there's a step which tells you about prepare a scanned copy of your signature of uploading. Why you need to do that? This is a very simplified thing. All of us can understand that, while uploading anything, you just need to put your signatures and scan your signatures and put there in. But what is the need here in that? Because there's a small flaw in the online things. You are claiming protection for your own work, and as far as registry is concerned, whether it be trademark registry, whether it be copyright registry, they are very particular that the person who has claimed and who has filed the application, that person's signature and that person's initials should match the person who have uploaded the documents as well. So in the very beginning itself, what they do, they cut short and they have made a very specific and a stringent step that you only have uploaded the document and which is matching your signatures which you have uploaded. Another category is that generally what people do, why I'm explaining this process is here, because what people do, what is the general practice is that I am claiming the protection for my work and I'm giving that work to third party, and that third party with their own name and signatures upload my documents, and that is how the process goes on, like an authorized agent. You can do that, but not initially in the first step, what I'm telling you here. Now, here the first step is there has to be a statement of further particulars. What does this statement mean? You know that you have to get protection for a play. Now, what exactly the play is about? What are the characters? Is there any mythological character? Is there any historical character? What is the storyline? And all those things need to come under that statement of purpose here. This form applies to literary, dramatic, musical, artistic, and software works. The sounds are also protected here. Click save to store your entered details and proceed. Now here you just have to get your details uploaded on the portal and that thing is under process. But copyright is only for the literary, dramatical, musical, artistic and software works. Now, next we come to trademark. This is another category of trademark, and this is very important. When I talk about trademark, this is important with respect to university purposes also, and for any startups which is initiated by law students or any other student for that matter, and general for day-to-day activities also, even for businessmen, for any other purpose who has just thought of starting a business or a startup, whether it be anything. So trademark is not only specifically related to law. This is so basic thing that everyone, even for the faculties who are teaching in university, and even if they they have thought of starting a teaching online thing or online teaching thing or any kind of that related to different courses related to law or any other thing. This is very important for those people. Now, what is trademark? Trademark is any sign that individualizes goods of a given enterprise and distinguishes them from the goods of its competitor. Now, it is a type of property, typically a name, word, phrase, logo, symbol, design, image, or a combination of these elements. Either it can be a word, phrase, logo, symbol, or even for that matter, a mixture of all these things. Now, the registration of a trademark after the commencement of the Trademarks Act shall be for a period of 10 years. Under this particular act, the Trademarks Act, you get the protection for your work for a period of 10 years. But this is, this can be renewed for another period of 10 years. But before, renewal of this particular thing, the person who is claiming the protection before the term is completed, term of 10 years, he or she has to move an application before the authorized or the concerned authority that the particular trademark that is about to expire and they want to get their mark renewed for another period of 10 years. Now, when we move forward, what all types of trademarks are there? I have, for the simplification and for a quick understanding, I have prepared this chart where you can see the word marks as well and device marks. Now, here, what is not mentioned, but that is in the procedure. What I need to explain about the trademark, word mark, and device mark. These are two different categories of mark. A word mark doesn't contain a device or an image or anything related to that. Just simply words. That is why it is called word mark. Like you can read Toyota, Progressive, Nuke, Newsweek, Forbes. These all are word marks. And the second below, the below is a device mark where you can see here the images of various marks like Cadbury, H&M. Now here you will see that these are include device mark includes color combinations also, words also, style of writing also, the way of presenting their mark. Like here you can see Puma. It is symbolized with a leopard or a cheetah image. Here the Puma word is not written. It is symbolized with an image. Similarly, Apple. Here you can see image of an apple. So these mark doesn't contain specifically or necessarily words itself only. These might contain the color combinations also, or a single color image, or just image. Anything of that sort comes under device mark. These are the two categories of trademark. Now, another category of trademarks is service marks and collective marks. Now, when you talk about service marks, the word itself is very suggestive. That service marks is applied by those people who are into service fields. Like here, I have just mentioned few marks, Amazon.com. So this is the service industry, and the above, right above that, you can see the collective marks as well. Now, there's another category under trademark which you call as well-known trademark. Now, what is a well-known trademark? These are the kind of category of trademarks which have created a goodwill in the market by coming into market through the channel of trade. Like before the mark could actually be registered as a trademark, it has already been functional in the market, and over the period of time, over years, it has created its goodwill, and that is why we have given these marks as well-known trademark, like Lux. So there's another story behind this particular mark, that before Lux could actually get a trademark registration for its mark, it was already operational in the market and has created a goodwill. Now, what happens when such category of marks are infringed? Like some other person copies your mark and started using that mark in regular trade practice. What happens? Now, for these particular things, such kind of infringement, you have a, recourse of passing over and pass off under the act, and you have the recourse of litigation to sue that person under court of law. So, if anyone tries to copies your or infringes your mark, then the remedy is for passing off. Now, what is the registration process of trademark? First, there has to be, before you could apply for registration of your mark under this category, you need to specify and make yourself clear that what kind of mark you are claiming protection for, whether it is a word mark, whether it is a device mark. And let me just inform about these categories like word mark and device mark. Both the kind of marks have a different liabilities. Like word mark is altogether a very important category of mark, because before granting any kind of protection over these marks, there has to be very evidentiary proof has to be of such a such a nature that there needs to be no confusion in the mind of registry before granting the protection under that category of mark. So those are word marks. Whereas device marks, because there are other color combinations also, sometimes there are words also, there are symbols also, there are signs also. So various other things are also considered and kept in mind before granting the protection of device marks. Now, similarly, as we do in copyright, in trademark also, we need to file an application before the registrar, specifying about our mark, the category of the mark, what kind of category of the mark is, service mark, collective mark, word mark, or device mark. Then you have to pay a requisite fees for that mark. And all the categories of trademark have different categories of fees. So word mark plays a major role. It has a a very the scrutiny process of word mark is different and very stringent. So there are other categories of marks also, and other different fees is prescribed for different categories of marks. Now, when you file that application goes through a refinement process, and the first process is the examination process, where the examiner, what does the examiner do here? The examiner examines that mark and conducts a search under in that portal for that particular mark. Now, what kind of search is that? Under that search, the examiner finds out whether there is any similar mark already existing related to this particular mark, which has come under the scrutiny process. Now, after the examination process, if that particular application passes that examination process, and the examiner feels that there is no similar mark, the examiner, after writing the comments, and pass that mark to another department. Now, this particular department, what does that department do? It makes that application open to the public to invite applications of related to objections. Like as a registry, I have decided that this mark, there is no similar mark uh, to this particular mark which has come in front of me. Now, what I do, I invite applications for objections that any person is there, he might not know that the person has applied for the trademark for this particular mark. That person is also able to know that, this is under scrutiny, and I object this because I have a mark and I am the prior user here. I will explain this word later, but for right now, this is important that if that person feels that I am the prior user of this particular mark, then that person files the objection, which is decided by the registry. And if that person who has filed the application before the registry for a particular mark, if he feels that all the objections are cleared and registry feels that this particular mark should be granted protection, then it goes out for publication. And that later on, the registry issues a certificate for that mark. Now here, what is important for people to understand, that what does the term prior user means. Prior user is very important. Prior user is a person who is using a particular mark prior or before that person who has applied in the registry for a particular application for a particular mark to claim protection. That is what he is the person who's called prior user. Now, this person is very important because simultaneously, if a person has already filed an application before registry to claim protection of a mark, and here comes the second person who claims that I am the prior user and I'm using the mark. Now, this person, if he is able to prove that I am the prior user and I'm using this mark before this person who has filed this application, this person is heard with all the evidences, and the matter comes to opposition. Here in the opposition process, this is a very important process. In under the opposition process, both the parties are heard by the hearing officer, based on their evidences which they produce before the hearing officer. And if he feels that this person who is claiming to be the prior user has more weightage and has all the evidences to prove that he's the prior user, then then the protection is given to that mark for that prior user itself. And the applicant who has filed the application protection, that application is dismissed. So this is the concept of prior user here. Now this is the same process. This is also the similar process like a copyright registration process, which I've already discussed in through these slides. Like trademark classification and search, that means you first have to classify your trademark, whether what kind of category is your mark, word mark, device mark, a service mark, or a collective mark. The second process is doing a elaborative search. And what does this search means? You find out through this search that whether any similar mark is already under existence or not, and has been granted protection at the same time or not. If you have filed an application for a mark and a similar mark is already under existence and which has already been granted a trademark, you cannot file that application, and your application or mark will be rejected. Now, another process is payment trademark registration fees. This is along with the form. When you apply along with your application, you need to file a requisite fees, which is different for different marks, as I already discussed in brief. Here, another step is trademark examination and reply to objection, which I have discussed that once the application is filed before the registry, it goes through various processes, and one of the processes of refinement is the examination process, where the examiner examines that application and decides whether that mark should be given protection or not. And if he feels that the mark is under you just have not taken the mark, you are actually using that mark. Now there are two things. People sometimes they apply for trademark registration, they get the protection also, and they do not use that mark for a long time. Now here a very important thing to note is that under these circumstances, that mark does not count, is not counted under an active mark. And the registry decides that since this particular mark is not under use for 2-3 long years, that means you're not using that mark, and some other person who is using that mark, even if he has filed that application later on, then also he's given protection if he is able to prove that through all the evidences that this mark is mine and I'm using this mark. After that, the mark is gone. It is given to another department for publication, and the certificate is issued later on. Now, I'm just discussing in brief what is the need for registration of the trademark. Trademark is very important with respect to academic purposes also, because when you are opening any, startups for education, or for even for that matter, online tutorials, and like there are various platforms, online platforms, who are delivering lectures for even for law, for entrances, for any other thing, for different courses. And they, for those people also, I will just mention that registration of your mark, registration of your brand under which you are carrying on your business is very very important before you could actually start on your business, because this is your, name. This, through this name, you are generating your goodwill in the market for that particular service, or for, if you're dealing in goods, for that matter. Now, for, I have just already discussed that you get a legal protection in case somebody is claiming, rights over your business, and is unable to prove through evidences that he's been using this mark, and he's been carrying on the similar business like you. Now, here you have the benefit because your mark is already registered and you get the legal protection under the act. Or secondly, brand identity and recognition. This is very important because when you're carrying on a business, it is for you, for the proprietor, for the entrepreneurs to understand that how will you be able to recognize, get recognition in the market through your brand name. And through your brand name, your goodwill is generated, brand identity is created. Third very important aspect is that market advantage and business growth. Legal recourse enforcement, which I have already discussed, that what legal recourses there is. Recourse for infringement of marks, that is their passing off. You can sue that person in court of law for the infringement of your mark. Licensing and expansion. Now, very important aspect. Why I have kept here this point at, in the end, because I want to discuss this in brief. It is not only that you have applied for a mark and you have got your mark registered, and you have started carrying on your business. Another aspect of this thing is that it is not your thing only. You have the option and you have the, opportunity also here to give license for your mark. All right, here what you can do, you can sell this mark to another person, because this is, this is the business, this is your idea, and this is your goodwill what you have generated through that service thing. So what you can do, you can sell off this thing to another person and getting consideration of it. So obviously your IPR, your intellect is, you are getting paid for your intellectual thinking, for your creativity, for starting of your business. When you sell that your business to another person through that goodwill and through that name only, brand name, which is the brand identity. And you can also give your mark on lease, giving license to another person to use your mark, and getting paid for that, getting a remuneration out of it, getting paid for that. So this is also because this is a category of property only. So it is, obviously giving something, some monetary benefits to you. Now, another mark we are discussing, another IPR is patents. Patents is very important. Now, what is patent? Patent is an exclusive right granted for an invention, which is a product or a process that provides, in general, a new way of doing something or offers a new technical solution to a problem. Here, important thing to note that there has to be novelty. Just for example, that if I am using crocin and another person comes and just adds and, tinkers with the salt present in the crocin already, and comes back with the, another package of crocin, which he says, that this crocin takes time, the earlier crocin takes time for 1 hour to react, and my crocin, it reacts in 5 to 10 minutes. So this is a novel step, and which is patentable. And everything which is around you, whether it be machines or anything else like laptops. Earlier we used to be use computers, and it was not user friendly. We could not carry these systems wherever we go. But then the idea came that you can use your laptops also, then you can use your mini books also, then the same thing which you can do on computers can be done in your phones also. Now these all are inventions, with stages. These all are the patented ideas. These are the examples of patent. Now, in principle, the patent owner has the exclusive right to prevent or stop others from commercial exploiting the patented invention. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the patent owner's consent. Similarly, because this is your invention, this is your idea, this was your creativity, this was your novel step which you have done. So, without your permission, nobody else, no other third person can use your idea, your invention. And this has the protection of 20 years. From the filing date of the application under patents, you get the protection for 20 years, which is subject to renewal and another for another 20 years. You can also get your application renewed, your patent renewed for another 20 years, subject to the filing of an application, which you move before registry. All right. Now, how all these IPR are important for academic purposes and specifically for universities. Now, IPR is the foundation of new university mode, and this has been provided by World Intellectual Property Office, which has, acknowledged this fact that it is a foundation of new university mode based on technology transfer. Now, what IPTT provides, it provides a new way for the universities to disseminate its knowledge and creative solutions for the goods of society, actively participate in the innovation ecosystem and economic development, reward, incentive faculty and staff. Now, what happens when you encourage students, for that matter, faculties also, they play a very active role in modifying these things. They need to inculcate and to disseminate their knowledge related to IPR and how they can grow as an institution, because it is not limited only to an individual student or a teacher. It is not limited in that way. Even a community, even a group of people can come together and come up with innovative ideas or some kind of creative entrepreneurship idea where they can use the benefits provided under IPR, and they can grow as as an institution. The university becomes a key source, catalyst, and participant in the dynamic innovation ecosystem. Now, this has been recently been discussed in Oxford University as well, and this has been a quote which has been adopted from the Oxford Science Park, which discusses these things because. When we talk about IPR as a nation, when we talk about India, now there are various government schemes which also provide what you can call is like they provide initiative opportunities and some kind of subsidies and various other things which are all some opportunities to universities and to students as well, who bring up their proposals for as a university or as an institution to the government, and they bring up their idea, and then as the as a group or as an institution, they take up that idea for the protection under IPR to a concerned authority. This is very important because the more we encourage students to bring up with the creative ideas, creative things, and to bring out some new inventions, some kind of things which act to uh, to say that they are actively participating in the nation's building and growth. Until and unless that happens, the use of IPR in true sense will not be achieved, or the objective of the IPR will not be achieved in true sense if it doesn't happen. Now, academics and students get caught in the quick change that affects the plan and delivery of academic courses. Not only related to the theoretical perspective, when we teach about IPR to students, it is very important for us to know as teachers, as faculties, that we need to understand IPR just in the manner like we have studied maths or science in our schools. This, as per my, if I what I feel is that IPR should be included at a level, at higher education level, so that even the students who are coming out of school, they have that idea, like just like the vocational courses they have started in schools and colleges. Similarly, in that manner, when in vocational courses also you bring up with the ideas or some kind of business or some kind of entrepreneurship idea. So I just say that why not to come as an institution together with students as faculties and bring up some kind of initiative intellectual ideas which can be protected under IPR. Now, this impact the lawyer's education as well in intellectual property as well as non-law programs that want to give their student education in intellectual property. IPR has historically been imparted by law faculties as law matters to law students. Now, what happens, what is to be discussed related to research perspective? Every university is being grant, they have they are given some kind some grants, some minimum grants from the government or from the state authorities to do research work. What I say is when researchers make use copyrighted content for coaching or for purposes like research, it must be assured that the use is inside the authorization acquired from the copyright holder, that you get the permission, and it is only related to the research perspective, not to infringe the particular copyrighted work that are concerned or within the scope of exceptions granted by Indian copyright legislation. Now, different courts interpreted the scope of numerous learning use related exceptions under Indian copyright law of India. Here, what they are trying to explain is that as researchers, as people who are doing research in law, like fifth year students, or for that matter, 3 year students who are doing 3 year courses from state universities, from private universities, what they do in their final year, they do research work related to the thesis or some kind of some topic related to IPR or copyright. What they do the research, and then they forget, or sometimes there is a deliberation in that effort that they do not give the due acknowledgement or due recognition to the person who from whose their work has been taken for their particular research work. So you have to give the due recognition to that person whose work you have copied for only specifically for limited purpose of research. You need to give that person's recognition. Now, an institutional repository may be created by the academic institution, and a connection to the same may be given on its official website. Theses, dissertations, articles, publications, and other internal publications shall be included in this collection. The researchers can apply these works in other open repositories in the similar topic zone in lack of an official repository. Researchers may be simulated to authorize their work under a free license so that other scholars could also utilize the research result by providing the researchers with correct attribution. Now, what happens? Uh, we are just working on the proposal. This is a thing which is related to research work, the researches which are conducted in universities by the students. There is no online portal or any kind of common platform with respect to various universities that where the researchers do research. They that particular portal is a repository where they are just compiling their research works and keeping it safe for other people to refer that work, their research work. So we are just working on these kind of proposals as well. Like there is under trademark, what happened that government has created an online portal. Similarly, I have just discussed an act which is the Plant Breeders Act. Now, what is under this act? That there is a online portal which has been designed by the government, where even for that matter, farmers can see that what is a plant variety or what has been a breeder's variety which is a new variety and which has come into existence. This particular act specifically talks about farmers and breeders. So there is a kind of repository, online repository, where you can see that to double check or double cross that whether you are not copying that person's work, are you not copying that person's variety, or you are not copying copying the step which has been used by a farmer or a breeder in developing a particular variety. And the recourse or the for the recourse has been provided under the act for that infringement. So here the my basic purpose is while discussing about various categories of IPR is that we as lawyers and students and all the faculties who are teaching in various state institutions and private institutions, they play a major role and a very active role in developing IPR. Why? Because every year so many students pass out and they do so many researches on different topics. As a university, we need to understand that we need to find that you know find those students and find a group of students, or find a group of faculty for that matter, who come up with brilliant and innovative ideas on behalf of universities, which for which a proposal can be made, and that proposal can be taken to a concerned authority for protection. And that is how play a major and active role in nation building. For that matter, and the basic purpose for IPR, intellectual property rights, the basic purpose was that to give that person recognition for his intellectual thinking or creativity or innovation, whatever he has done, to give recognition in terms of money, to give to give recognition in terms of brand identity, when that particular industry is doing and carrying on its business for various goods and services. So all my priority and all my understanding, what has been developed over these past 11 years while working for IPR, is that as a nation, as students, as practicing advocates, we need to understand that we are studying law, and nobody else other than people who are dealing with law, who are reading law, who are making law, can understand its complexity. And when we know the law that better, why not to come and come up with ideas and creative ideas and inventions and novel steps? Or for that matter, people say that over like past 2 years, I've been experiencing that universities have been playing very vital role in encouraging students to bring in ideas, and they get those ideas are being patented in science background, in BTech, in any other. So we need to encourage our students as faculties, and as faculties, we need to understand that we also have, that intellectual, that creative thinking, that we can come up with that idea, and we can, put one step forward in nation building and nation's growth. So here I will try to wind up my presentations, and I hope that the people who are listening to me through this module, and all the teachers or the faculties who are attached with this online portal, and listening to the IPR, and if they know about IPR, even if they don't know about IPR, they are not a practice, they are not practicing advocates, or any other people who are listening to and seeing these slides, they need to understand that we have the opportunity to develop IPR and nobody else. Thank you so much.
Thank you, ma'am. Now we have a question and answer or discussion round. And the question from the participant is, how can researchers and institution effectively manage and enforce their IP rights?
Yes, as to for students, I would say that I have been a student, and we all know that at university level there are various opportunities which are given to students for small startups. Like, even for that matter, for university purposes as well, they do research work for a particular they're given some kind of projects or something like that, where they can give up, they can bring with some some kind of ideas which are reproduced in writing, where you can get that your work into writing, and then that proposal we can take up with the head of the institution, and we can represent the university, and we can take up that proposal to the government. That is how at students level we can make initiatives, because as researchers you are continuously researching about different topics for current matters as well. We all read about current affairs, and when we this is a developing nation, and we all must be aware what kind of issues are there in the market, in specifically for intellectual property rights. What are the issues which are faced by the Indian government? Or we can work on that, we can bring those ideas, we can go up to our faculty members, we can make a proposal on that. As researchers, we can research on that. And it is not a research is not only related to your ideas and that is written on paper. No, we need effective evidences where you are getting that source, getting that knowledge, so that you can attach those ideas as evidences, and we can take those proposals to the government agencies. We can get those ideas protected.
Thank you, ma'am.
Thank you so
Now,
much.
ma'am, the time for the formal vote of thanks. And I, Dr. Sadaf Khan, on behalf of entire Faculty of Law, extreme my grateful, ma'am, for your valuable time and, ma'am, your insightful lecture. Thank you, ma'am. Thank you so
Thank
much.
you so much, ma'am. Thank you for giving me an opportunity and sharing my knowledge. Thank you so much, ma'am.